Ladies and gentlemen of the jury, what is the value of a human life? To grieving parents who've lost a 14-year-old to senseless acts of violence, a human life is priceless. But on May 28, 2023, Chaiki Rick Chow, the defendant in this case, determined that Cyrus Carmack Belton's life was worth less than 4 bottles of water.
He put the water back. 1 bottle, 2 bottles, 3 bottles, 4. He opened the cooler, took them out, paused, and methodically returned every single one. Then he closed the door and walked toward the front of the store. 30 minutes later, he was shot in the back on a public road in Columbia, South Carolina. He was 14 years old. And here is the part that should stop you cold. The man who shot him had installed an intricate multi-angle camera system that recorded everything. Every aisle, every interaction, the parking lot, the street beyond. The whole sequence, frame by frame, preserved on video. The cameras that were supposed to protect his store became the most important witnesses at his murder trial. Because those cameras showed exactly what happened, and what they showed was not what the shooter claimed. This is the state of South Carolina versus Chaiki Rick Chow, and it begins, as so many tragedies do, with a misunderstanding that one man refused to let go of. May 28, 2023. A convenience store and gas station at the corner of Park Lane and Springtree Road in Columbia. It is around 8 in the evening. A boy named Cyrus Carmack Belton walks through the door. He is wearing a red hoodie with a small front pocket and carrying a black backpack. He is 14 years old. He complies immediately when the co-owner asks him to leave the backpack on the water cooler. Store policy. No argument. He puts it down and begins to browse.
We know this to be true because the defendant in this case, Chaiki Rick Chow, had an intricate camera system that captured almost every interaction within that store and multiple camera angles. He also had camera angles outside of the store on the premises of the store and immediately adjacent to the store so you could see what happened at the beginning of Springtree as his property ended. So Cyrus walked into that store, red hoodie, small pocket in the front, black backpack, and he walks in and he immediately is asked by the co-owner, Alice Chow, to remove his backpack. That's store policy. Cyrus complies.
Walking the aisles the way any kid in a corner store walks the aisles. Looking at candy, looking at water, looking at nothing in particular. He is being watched from the moment he walks in. Alice Chow, the co-owner, follows him, leans against a post, and tracks him through every aisle. Her adult son, Andy, working the counter, watches between customers. 2 sets of eyes on one 14-year-old boy, the entire time he is in the store. Cyrus walks to the back right corner, opens the water cooler, takes out 4 bottles, one by one, holds them for a moment, then puts them back. 1, 2, 3, 4. Closes the door, turns around, starts walking toward the front.
Finally, Cyrus walks to that back right corner of the store. And again, we know this to be true because of that intricate camera system that Mr. Chow installed. He walks to the back. He opens the water cooler, leans the water cooler against his his left shoulder, and takes out 4 bottles of water. 1, 2, 3, and 4. And after a second, he pauses and methodically puts all 4 water bottles back into that cooler. 1, 2, 3, and 4. He closes the cooler and begins to walk back towards the front of the store.
That is when it starts. Alice Chow asks if he needs help, then accuses him of stealing water, tells him to empty his pockets. Andy says the same thing from the counter. You took some water. Give it back. Cyrus says he took nothing. Says it again and again. He does not curse. He does not raise his hands.
And it's at that point that the verbal confrontation begins. And I say confrontation because Cyrus said nothing. The co-owner of the store, Alice Chow, asked if he needed help and eventually accused him of stealing water, told him to empty his pockets. The adult son, Andy, who was watching, said the same thing. You took some water. Give us back the water. Cyrus said, I took nothing. I didn't take anything. I didn't take anything. And they continued to verbally attack him, accusing him of stealing water.
He does not threaten anyone. He picks up his backpack and walks toward the door, doing the one thing any reasonable person would do when falsely accused, trying to leave. Then, Alice says something in Cantonese. Andy runs around the counter. And from the back office, Chaiki Rick Chow emerges armed with a .45 caliber Glock pistol and follows the boy out of the store. Now pause here, because what happens next is the entire case in 130 yards. Cyrus walks out, turns right, hears them behind him. He runs. He runs so fast.
Cyrus walks out of the store, takes a right, slowly, and hears them yelling, running after him. Turns to see, and again, the camera system shows these things, and he takes off running. Cyrus tries to run through the parking lot to the point to where he runs out of his Air Force One Nike shoe. Runs out of his shoe. Doesn't turn around to pick it up because you have an adult male running behind you with a .45 caliber Glock pistol who has falsely accused you of stealing.
He loses his Nike Air Force One off his right foot. He does not stop to pick it up. He drops 2 cell phones, one belonging to him, one to his mother. He does not stop for those either. Drivers on Springtree Road have to slam their brakes as he crosses traffic. He falls, gets up, falls again, cutting his shin, drops his backpack, keeps running. Rick Chow and his son chase him for over 130 yards, off their property, onto a public road. That is not a detail. That is not a footnote. Solicitor Byron Gibson, the 5th Judicial Circuit prosecutor leading this case, made sure the jury understood exactly what that distance meant. 130 yards, he told them.
In total, Chaiki Rick Chow and his son chased Cyrus Belton over 130 yards off of their property onto a public road in Columbia, South Carolina. And eventually, after Cyrus fell a couple of times, Chaiki Rick Chow fired the fatal shot, which ended his life. Folks, 130 yards is a football field. No, in fact, it's a football field, goalpost to goalpost, plus 10 yards.
That is a football field, goalpost to goalpost, plus 10 yards. Eventually, Cyrus falls for the last time, and Rick Chow fires a single shot that kills him. Let's talk about who Byron Gibson is, because in this courtroom, the prosecutor is one of the most important characters in the room. Gibson is not performing outrage. He is precise, deliberate, and methodical in a way that makes his controlled anger far more effective than shouting would be. He opens with a question. What is the value of a human life? He closes with the same question. Everything in between is built to make the jury feel the full weight of the answer. This is a man who knows that the most persuasive thing a lawyer can do is trust the facts to speak and get out of their way. The defense attorney is Jack Swerling.
Is why a 14-year-old would be illegally possessing a semi-automatic pistol, wandering the streets with that pistol, with a laser attached to that pistol. A laser to go ahead and ensure better accuracy when you fire the weapon. a semi-automatic pistol that was loaded.
His opening statement is technically competent and strategically clear. He acknowledges the tragedy. He expresses sympathy for the Belton family. And then he pivots to the argument that will carry the entire defense. This case is not about water. It is about a 14-year-old who was illegally carrying a loaded semi-automatic 9mm pistol with a laser sight, who pointed that weapon at Andy Chow on a public street, and who left a father with a split-second decision to make. Swirling paints Rick Chow in careful strokes. Born in Hong Kong. His wife Alice, born in Malaysia. Both came to the United States as students. Both became proud American citizens. Rick held a computer science professorship at a South Carolina university. Alice earned her CPA license. They raised 2 sons, both University of South Carolina graduates. They bought the Shell station and ran it for 10 or 12 years. These are not criminals, Swirling tells the jury. These are people who worked for everything they had and were trying to protect it. He is not wrong that Rick Chow had a concealed carry permit.
He illegally entered the store because there was a sign posted, it's illegal to go ahead and enter the store with a weapon. Versus what Mr. Chow did. Mr. Chow had a concealed weapons permit. He never drew his weapon. He was authorized to have a weapon, but he didn't draw that weapon until his son was in danger of being shot.
He is not wrong that a 9mm pistol was found near the scene. He is not wrong that a 14-year-old should not have been carrying it. But here is what the defense cannot make disappear. And this is the part that will determine everything. The prosecution's theory is straightforward. Cyrus Belton stole nothing. The cameras prove it. He was falsely accused, verbally harassed, and when he tried to leave, he was chased down a public road by an armed adult male. The prosecution believes that in the chaos of that chase, as Cyrus fell and his backpack went into a ravine, the gun he was carrying spilled from his pocket.
They chased him out of his chute, dropping phones around down Springtree Road. After he tripped over a curb, fell, dropped his backpack, we believe that gun spilled out of that pocket. And within moments after that gun spilled out of that pocket, that man shot Cyrus Carmack Belton in the back with a .45 caliber pistol.
He is not wrong that a 9mm pistol was found near the scene. He is not wrong that a 14-year-old should not have been carrying it. But here is what the defense cannot make disappear. And this is the part that will determine everything. The prosecution's theory is straightforward. Cyrus Belton stole nothing. The cameras prove it. He was falsely accused, verbally harassed, and when he tried to leave, he was chased down a public road by an armed adult male. The prosecution believes that in the chaos of that chase, as Cyrus fell and his backpack went into a ravine, the gun he was carrying spilled from his pocket.
Chow sees a young man pointing a semi-automatic pistol at his son, who's backing up with his hands up, and Rick Chow fires his gun to protect his son. We submit to you that that was reasonable. It was a reasonable impression that his son was possibly going to get seriously injured or die at the hands of somebody who had a gun pointed at him, that that was a reasonable belief.
That when Andy Chow saw Cyrus with the gun and began backing away with his hands raised, when he yelled that the boy had a weapon, when Rick Chow arrived and ordered Cyrus to drop it, and Cyrus did not, the shot that followed was legally justified as defense of others. That the entire sequence, starting with following a suspect off private property and ending with a fatal shot on a public street, was a reasonable exercise of a father protecting his son. This is where the law becomes the battlefield, And you need to understand the two legal concepts that will decide this case. The first is murder with malice aforethought. In South Carolina, murder requires that a person kill another with what the law calls malice, not necessarily premeditation, in the sense of planning it for days. Malice, in legal terms, means an evil heart, a wicked mind, an intentional killing without legal justification. The prosecution must prove this beyond a reasonable doubt, which means beyond the kind of doubt that would cause a reasonable person to hesitate before acting on a belief. Not every doubt, a reasonable doubt. The distinction matters enormously. The second concept is defense of others. This is the oldest principle in American self-defense law. You do not have to stand by while someone threatens the life of a person you love. If you reasonably believed your son was in imminent danger of death or serious bodily harm, the law permits you to use deadly force. The critical word is reasonable.
The young man was pointing a gun at his son. Defense of others. Is that an immediate threat, an imminent threat? Is it a reasonable belief that your son is in danger of serious bodily harm or death? I submit to you there's not going to be any question about whether or not it was reasonable or whether it was imminent, or it was reasonable to believe it was imminent. And you are, under the law, since the beginning of time.
Not what Rick Chow felt in his gut. What a reasonable person in his position would have believed. And here is the crucial procedural point. The burden is not on the defense to prove self-defense. The burden is on the prosecution to disprove it beyond a reasonable doubt. That is not a loophole. That is a constitutional protection. But it means this case will be decided by a very precise legal question. Was the belief reasonable, given everything that led to that moment? And that is where the 130 yards becomes the load-bearing wall of the prosecution's case. Here is what I want you to think about, and I am genuinely curious what your instinct says. At what point in a chase does following someone become pursuing them? The defense calls it following. The prosecution calls it a chase.
I again say this to you. The state wants to frame this as a situation where a young man may have taken some small item from a convenience store, wrongly accused, chased, and he wasn't chased, he was followed, chased and shot down because he had taken something from that convenience store. I submit to you it's not that simple.
He began chest compressions. He cleaned vomit from the boy's mouth. He gave him mouth to mouth. He stayed until more qualified help arrived. He stayed. The defense wants the jury to hold that image alongside everything else. The prosecution wants the jury to ask why a man who had just made a lawful defense of others decision would need to render aid in such desperate, personal, physical terms. Both interpretations exist inside the same set of facts. Here is the detail that cuts through all of it. 15 hours. That is how long it took from the shooting to Rick Chow's arrest for murder. 15 hours. The defense argued this was premature.
But within 15 hours, before any of the investigation really had focused with detailed interviews, with forensics things from the labs as to whatever ballistics, DNA, whatever the issues were, within 15 hours, when Mr. Chow was called down, he was told to report to the Sheriff's Department and be placed under arrest for murder. That's how long it took, 15 hours.
That no forensic analysis had been completed, that no full investigative interviews had been conducted. They are not wrong that 15 hours is fast. What they do not address is what law enforcement saw in those 15 hours that made them move. The cameras, the footage. 130 yards of footage that showed every step of what happened from inside that store to the moment on the road. The cameras Rick Chow installed told the story he could not control. Here is what this case teaches us about something most people never think about until they need to know it. The moment you leave your property, the legal framework changes. Self-defense and defense of others on your own premises operates under very different conditions than a pursuit onto a public street. A store owner has significant rights to protect his property and persons on it. Those rights do not follow him out the door indefinitely. If you ever find yourself in a situation involving a dispute on private property, the single most important legal decision you can make is to stay and call the police rather than pursue. The moment you follow someone off your property and onto a public road while armed, you are no longer simply defending your store. You are making an active choice whose legal consequences the law will examine with extraordinary scrutiny. The prosecution understood this. Solicitor Gibson framed it plainly for the jury.
You get a chance to assess that, and I'll ask as you start asking those questions that bounce around in your head. In what world do you get to falsely accuse a 14-year-old of stealing, chase a 14-year-old 130 plus yards down a road while you're armed with a pistol, shoot that person in the back, then claim you're defending your son?
In a single sentence that captured the entire case, a grown man falsely accused a 14-year-old of stealing, chased him down the road while armed with a pistol, shot him in the back, and then claimed he was defending his son. That is not a question about guns or youth or culture, he told them. That is a question about what one man chose to do with his feet and his weapon on a May evening when every camera he owned was watching.
There's an 11th century philosopher named Omar Khayyam. And one thing that he wrote back then was, "The moving finger writes, and having writ moves on. Nor all your piety nor wit shall lure it back to cancel half a line, nor all your tears wash out a word of it." Now I know y'all are looking at me kind of like, what is this dude quoting some 11th century philosophy for? I'll tell you that at the end of this case, I will explain to you why something written back in the 11 and 1200s rings so true today in this courtroom in 2026 about a case where that man murdered a 14-year-old in 2023.
Having writ moves on, nor all your piety nor wit shall lure it back to cancel half a line. He promised to explain at the end of the trial why something written nearly 1,000 years ago would ring true in a Columbia courtroom in 2026. What he meant, even if he did not say it yet, was this. The cameras wrote what happened. The footage exists. It does not adjust for regret. It does not account for grief. It does not care about intent or narrative or the American dream. It simply recorded what a man chose to do, step by step, yard by yard, for 130 yards. And in this courtroom, that record is the whole case. A 14-year-old put the water back. The cameras saw it. So will the jury.